Withholding kids. What is a writ of habeas corpus? That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Attorney Mac Pierre-Louis, lawyer, mediator, arbitrator, working out of Florida and Texas. And with me, again, is my colleague, Dannielle Sims. Dannielle, how are you doing?
I'm well. How are you doing?
Good, thank you so much. All right, we are back to discuss a new legal topic, and this one is writ of habeas corpus. It's when we deal with returning kids and when they're being hidden or they're being withheld by one parent or they'll be held by somebody.
Right.
And so we're just going to have a little conversation about this and our experiences, what we've seen, and why this might come up in the courts. But first, let's talk about who you are. Dannielle, introduce yourself.
Hi, guys. You guys, if you've ever seen this channel before, you've seen me. I am a lawyer practicing here in Harris County, Texas. I practice in Harris County, Montgomery County, Galveston County, Brazoria County. I practice in Texas, guys. I practice exclusively family law. That includes divorces, custody matters, child support. And I also do a lot of cases with the Texas Department of Family and Protective Services, otherwise known as Child Protective Services, otherwise known as CPS. I do a lot of CPS defense work for parents. I've done defense work, well, not necessarily defense work, but I've done work representing children as well. But my passion is always representing parents and their constitutional rights, which, you know, also includes representing the constitutional rights of a child. I have been practicing for about, I want to say 12 years now. I know I look very, very young. I mean, hey, it's, you know, moisturizer, but, you know, this is my passion. This is what I like to do. And I love helping people.
Yes. So let's talk about this way we help people. And that is through what we call writs of habeas corpus. Now, that's a mouthful. Okay. That's Latin. And in the law, we know that to mean
Latin for returning the body.
Yes. And so literally it's return the child to the other parent or return the child to the courthouse. But why would you even need to do this? And so let's talk, Dannielle, just about our experiences and when we have seen that this sort of lawsuit come up. So when do you typically see that this is even needed?
So typically I see it when there is a court order in place that says Bob is supposed to have the child on XYZ date, but Sally or Fred have kept the child from Bob on XYZ date. The important thing for people to know is that the person who is filing the writ or has requested the writ must have the superior right to possession of the child. Mm-hmm. So, for example, if you come in there and actually, let me back up a little bit. One of the things that you have to know about a writ is the notice requirements are a lot tighter than any other lawsuit. Usually you're dealing with a 3-day notice, a 10-day notice, however X amount of date notice. With a writ, because of the way they're designed and what you're doing, you can get almost immediate relief as long as you can get that notice to that person. Sometimes you can get them at the courthouse same day, next day, 2 days later. The reason that superior right to possession is so important is because sometimes you'll see situations where I filed a writ, I've served you, but guess what? When I was actually able to get you in court, it wasn't my day to have the child. So the court couldn't give me relief. So it's imperative to know that when you are seeking a writ, you better be doing it when you have a superior right to possession. Because sometimes I have folks who their period of possession begins Friday at 6. I can't do a writ for you at 6 p.m. at 7 p.m. on Friday because we're not going to be able to get to court. And by the time I'm able to do the writ, you're not going to be entitled to possession on that following Tuesday, right?
Yeah. Cool. So a lot of times this becomes the issue, and that is by the time that the writ can be executed, the situation might have changed. A lot of times, in my experience, the situation kind of resolves itself. And we'll speak to that. What do lawyers typically do to kind of make it happen where a writ is kind of used or not really used and then gets resolved with or without court?
Generally, what I try to do is have my client reach out to the other parent or give me the contact information for that parent so I can reach out to the person before we have to start litigation. Obviously, that's at a time when that person is not represented. So I usually try to call and say, hey, I really don't want to have to file this against you, because not only will you have to come down to the courthouse, but you're going to have to pay my attorney's fees, and those are really hefty. So do you really want to have to do that when we can resolve it ourselves? If I have someone that won't do that, sometimes it really just takes starting the litigation, meaning getting them served. Sometimes when you get somebody served and they really realize, like, oh, shoot, I know this is a family-friendly channel, but oh, shoot, oh, darn, I'm about to have to go to court, it will result in someone saying, here, fine. So generally I try to resolve it, but please keep in mind that just because you've said here, fine, doesn't mean I won't pursue my fees, because that person still had to pay to get you to comply. But those are some of the ways that I try to avoid litigation.
Yeah. So would you say that writs of habeas corpus have cousins, one of which are in attachments, another one might be in enforcement? So before we get into the mechanics of the writ and what we do when we file and all that, what are some similar routes that people might have to, entertain if if the goal is to get a child to be returned back?
My favorite route is the enforcement route, because with enforcement, specifically for possession and access, because that's what we're talking about today, you are dealing in situations where that person who is violating the order can land themselves in jail. And so what I've often found is the threat of jail time, the threat of even a suspended sentence, aka our family version of, I guess, probation. Once you put that on the table and you tell this person that, hey, sure, you might have to pay me back my attorney's fees, people might say it's just money. The threat of loss of liberty is a big deal, because people lose jobs that way. Plus, who wants to go sit in a cell? Nobody wants to do that. And so for me, what I do is I will instruct my client, hey, you might not get this weekend, but I like to have you to have at least 3 violations. And so therefore, once I get that person served, you'll see how quickly they will start to comply with the order. And you still get to pursue your enforcement while still seeing your child, because they've still violated. And you don't have to worry about superior right to possession.
Okay, so let's talk about now the steps. So what would you say are the ABCs of getting a writ accomplished, a writ of habeas corpus accomplished?
Well, you better get yourself to your lawyer in a time that allows that person to be able to file. You still have the superior right to possession, and service can happen. So, like, for example, when I told you about the Friday at 6 p.m., if they don't release Friday at 6 p.m., but your period of possession ends Sunday at 6 p.m., you're not going to be able to do a writ in that situation. But let's say hypothetically it's for Christmas, which just passed. If you've got a period of possession for Christmas from the time the child's school is releases for Christmas, to December 28th, and you come to me at the time the child's school is released, or you come to me the next day, I have enough wiggle room within that time to get that person served. So generally what I will do is draft that writ, have that person served as soon as I can get it accepted by the clerk, get citation issued. My general thing is I like to walk it through. I like to go to the clerks and say, hey, we really need to push this through, and try to get it done within a good time frame. Get that person served and have them get themselves to the courthouse so they can explain to the judge what's going on. The issue when you're at a writ hearing really and truly is who has the superior right to possession at that time. You will see people come in and they'll say, well, this is why I'm not releasing the child. Well, unless they, and there's exceptions to everything, but generally when there is a modification pending or they are seeking temporary orders, what a judge will do sometimes is hear those things at the same time, because that's kind of what the statute sort of allows, without getting into too many details. There's a lot of nuances to it, but that's a way to defend a writ, right? Or saying this person does not have a superior right to possession, or this person is not named in the order, or this person is not a parent who also, has a right to possession, things of that nature. Because sometimes you'll have grandparents who want to do writs, but the question then becomes, what puts you in the seat to think that you can file a writ?
Yeah, so there's multiple parties who might be implicated in such a thing. So it's not necessarily just the 2 parents. A lot of times there are other factors, other parties who come into play. But let's talk real quick about something that I guess a question is begged, and that is, well, why wouldn't somebody who wants to withhold a child just say, haha, since it's pointless to do a writ anyway because of the short time frame, because you're going to be getting the child back anyway, I'm just going to withhold and risk that nothing's going to be done about it. So what should that person still fear?
Well, you can always feel, first of all, if they are served and the person goes forward, gets a default against them, and they still don't comply, you have what's called a writ of attachment, meaning a officer can then show up to your door and pick that kid up. That can happen. You also are in a position to where you are just accruing violations for an enforcement. And just because, you have won the battle, it doesn't mean that you're going to win the war. Plus, on top of all of that, guys, being able to comply with a court's order, within reason, obviously, but being able to comply with the court's order speaks to your parenting abilities and your ability to co-parent. So let's say, okay, he's not successful with the writ. Okay, we're not doing a writ of attachment. Okay, they weren't successful with an enforcement. What makes you think they won't be successful with a modification where they talk about, look, this person has withheld this kid for no reason, failed to follow court orders, didn't show up, didn't do XYZ. Is that in the child's best interest for them not to see the parent? Without some sort of factual bases that supports your claim, you are setting yourself up for failure.
Yeah. And so we're running out of time, but real quick, a lot of times a writ might just be one part of the multiple remedies that a person needs to basically set you up to take custody from you. So you got to be very careful that just because a writ's not successful, it might not turn into something in the long term. The other thing is attorney's fees. This stuff can get pretty expensive. And if somebody had the right to file a writ, most likely they will also have a right to at least get attorney's fees against you. And the last thing you need is a judgment against you to pay attorney's fees back. So do the right thing, follow the court order. And if you have to protect your child in some ways, guess what? There are mechanisms for that, right? The most likely one is modifications or emergency modifications, not simply deciding I'm just going to withhold the child forever.
Right. And please note that I'm one of those attorneys where if the fees are in my name, I will find them and I will seek them and you will pay them.
Yes, that's going to be the lines from a new Liam Neeson film. Okay, I will find you.
I will find you.
All right, guys, that's it for now. So if you enjoyed this, make sure you check out more on lmipodcast.com. Okay, signing off, everyone. Take care.
Bye, guys.
Bye-bye.